Hi everyone, before we begin this episode, I just want to play a quick promo for another true crime podcast titled Citizen Detective.
Do you obsess over cold cases?
Do you go down endless rabbit holes on online forums, searching for clues to solve your pet case?
Are you an armchair sleuth? If so, we'd like to invite you to check out our new podcast, Citizen Detective.
I'm Mike Morford.
I'm implicates.
And I'm Dr. Lee Meller. We work hand in hand with citizen detectives just like you to examine some of the most puzzling unsolved mysteries out there.
Citizen Detective is out right now, and new episodes drop every other Saturday.
Subscribe now so you don't miss a single episode of Citizen Detective.
July 7th, 1973. Tampa, Florida. The nude body of 34-year-old Earlene Barksdale is discovered in the back office of a children's clothing store she owns after she has been raped and shot in the head in an apparent robbery. Police soon focus on a suspect named Joseph Green Brown, who was involved in a similar robbery at another location on the exact same date, and after he is implicated by an accomplice, Brown is charged, convicted, and sentenced to death for Earlene's murder. However, since the case against Brown is fraught with problems, his conviction is eventually overturned, and he's released from prison in 1987. Even though there seems to be evidence implicating Earlene's spouse as a possible alternate suspect, no one else is ever charged with her murder. After that, the trail went cold. Hello everyone, and welcome to our latest episode of The Trail Went Cold. I'm your host Robin Warder, and today we're going to be exploring a case from Florida which is fraught with controversy, the 1973 murder of Earlene Barksdale. Earlene was a mother of 5 children who was found raped and shot to death at a children's clothing store she owned, and the investigation would lead to a black man named Joseph Green Brown, who would be charged and convicted with Earlene's murder and sentenced to die in the electric chair. After nearly a decade on death row, Brown was only 15 hours away from execution before he was granted a stay, and a federal appeals court would eventually overturn his conviction, leading to Brown's release after over 13 years in prison. The only real evidence against Brown was the testimony of a criminal associate who placed Brown at the murder scene, but he would recant his story multiple times, and the prosecutor at Brown's trial flat out lied to the jury about the so-called murder weapon and the ballistics evidence. Furthermore, it seemed like there was more compelling evidence pointing to Earlene's spouse, who was a prominent and well-connected local attorney, but even after Brown was released, the state still continued to maintain that he was the killer all along, and showed no interest in performing a new investigation or looking into alternate suspects. On the surface, this seems like a racially motivated miscarriage of justice, where corrupt law enforcement decided to pin the murder of a white woman on an innocent black man, but for reasons which I'll get into much later, this story is actually a lot more complex than your standard wrongful conviction. Over the past decade, an unexpected development has really muddied the waters in this case and created additional controversy. So on this episode, we're going to perform an in-depth exploration into this crime and try to figure out who was actually responsible for Earlene's murder. However, before we get started, just a quick reminder that The Trail Went Cold is a weekly podcast, which is currently available for download on several platforms, including Apple Podcasts, Stitcher, Google Podcasts, and Spotify. So if you like this podcast, be sure to subscribe to it, and please leave us a rating or review on any of those sites to help spread the word and garner us more exposure. The Trail Went Cold is on Patreon, so if you would like to learn how to support the show, please visit our page at patreon.com/thetrailwentcold. For as little as $1 a month, you can garner access to exclusive rewards, which may include stickers and thank you cards, early access to episodes, and bonus content. So with all that out of the way, let us now delve into the murder of Earlene Barksdale. Our story begins in Tampa, Florida in 1973, and her central figure is 34-year-old Earlene Treva Barksdale, who lives in the adjacent incorporated city of Temple Terrace and has a total of 5 children. Originally born in Ohio, Earlene had her 3 oldest children with her first husband, but when their marriage came to an end, Earlene became romantically involved with Fred Barksdale, a prominent attorney who was 17 years older than her, and first became acquainted with Earlene when he handled her divorce proceedings. The couple have been engaged in a relationship for 12 years at this point, but even though Earlene has taken Fred's last name and bore her 2 youngest daughters with him, they have never officially tied the knot. You see, Fred is still legally married to his first wife, Susan Barksdale, who lives in Tampa's Sunset Park neighborhood and has an additional 2 children with her. It seems like Fred splits his time living with his 2 separate families, and Earlene's oldest children would later say they had no idea Fred was married to another woman. Even though Fred was away from home a lot, they just assumed that was because his job as an attorney kept him busy. At this particular point, Earlene and a female friend of hers named Jerry Fox are co-owners of a children's clothing store called the Just Kids Shop, which is located on Tampa's Bush Boulevard. On Saturday, July the 7th, Earlene went to work her shift at the Just Kids Shop, while Fred took their 2 youngest daughters on an outing to the nearby resort town of St. Pete Beach, located around 30 miles away. According to Fred, they were expecting Earlene to join them at the motel when her shift ended at work, but she never arrived, and even though Fred called the clothing shop multiple times to check on her, there was no answer. On 2 separate occasions, Fred called Earlene's oldest son, Matt Evans, who had just graduated high school, and asked him to go to the shop to check on his mother, but since Matt did not believe there was any cause for concern, he refused to do so. This compelled Fred to drive back to Tampa in order to check on Earlene himself, and he arrived at the Just Kids Shop shortly before 10 p.m. The front door was locked, and Fred would later say that the shop, quote-unquote, didn't look quite right, so he decided to break the door down and bust his way inside. When Fred checked the back office, he discovered Earlene's nude body on the floor. She had been shot once in the head below her left ear, and the murder weapon was later determined to be a .38 caliber Smith & Wesson special revolver. The Tampa Police Department were summoned to the scene, and since $100 appeared to be missing from the cash register, it initially seemed that Earlene had been the victim of a robbery gone wrong. It appeared that Earlene had been raped, and since traces of semen were found in both her mouth and vagina, there was speculation that 2 assailants may have been involved. However, no fingerprints could be found at the murder scene, and since this was still several years before DNA profiling became a tool in criminal investigations, all tests performed on the seminal fluids were inconclusive. It also turned out that Earlene's co-owner of the shop, Jerry Fox, was out of town on the day the crime took place. While Earlene's exact time of death could not be determined, it was estimated that she was killed sometime during the early afternoon, several hours before Fred found her. One of the first investigators assigned to the case was Detective Dick Rivette, and in an ironic turn of events, it turned out that Rivette and his wife had frequented the Just Kids Shop earlier that same day and purchased a dress for their newborn child from Earlene only hours before she was murdered. Right from the outset, Rivette had issues with the theory that the crime was a robbery gone wrong, because even though money was missing from the cash register, a large, expensive diamond ring was still on Earlene's finger when her body was discovered. Rivette immediately started focusing on Fred Barksdale, who had traveled to St. Pete Beach with his daughters before he discovered Earlene's body, but Fred himself readily admitted that there was a 3-hour window during the day in which he had no one else who could vouch for his whereabouts or provide him with an alibi. However, any suspicions Rivette might have had about Fred were quashed when another detective named William Biebler became lead investigator on the case. Biebler was longtime friends with Fred and became incredulous over the idea that Rivette believed Fred was capable of murder. Fred was also well liked by the entire department in general, since he had a policy of representing police officers pro bono if they ever went to divorce court and needed an attorney. When questioned, Fred denied that there were any problems in his relationship with Earlene and claimed he did not even own a gun, and after passing a polygraph, he pretty much dropped off the radar as a potential suspect. Well, the investigation would move in an entirely different direction on July the 8th, the morning after Earlene's murder took place, when a 23-year-old black man named Joseph Green Brown suddenly decided to flag down a patrol car and turn himself into the police to make a confession. Brown originally hailed from Charleston, South Carolina, and had lived in foster homes since the age of 9. He only had an 8th grade education, and had moved to Orlando months earlier in hopes of finding employment there. When that failed to materialize, Brown decided to move to Tampa, but since he still had issues finding work, he soon hooked up with a criminal named Ronald Floyd, who enlisted him to be his accomplice in an armed robbery. Indeed, at around midnight on the evening of July the 7th, several hours after Earlene Barksdale was believed to have been killed, a couple were attacked and robbed by two men inside their motel room at a Holiday Inn located on Cypress Street. Brown confessed his involvement in the crime to police and said that he had molested the female victim and forced her to remove her nightclothes at gunpoint. While Brown was planning on raping the woman, she begged him to stop, and he decided not to go through with it. So he and Floyd tied up the couple before fleeing the scene. Brown said that he immediately regretted his actions and felt great remorse over what he did, which is why he decided to surrender to police the following day. Ronald Floyd was soon arrested for his role in the robbery, along with another man named Raymond Vinson. Even though Vinson was not personally present when the robbery took place, he wound up being charged as an accomplice because the two perpetrators had borrowed his car to commit the crime, and Brown used Vinson's gun, which he turned over to the police. Well, it turned out that this gun was a .38 caliber Smith & Wesson revolver, the same type of gun which was used to shoot Earlene Barksdale, and even though her murder and the Holiday Inn robbery had taken place in different sections of Tampa, Detective Biebler was struck by the similarities between the two crimes, and the fact that they both took place on the same date. Over the course of the next 3 months, Brown and Floyd both agreed to plead guilty for their roles in the Holiday Inn robbery, and would remain locked up in the Hillsborough County Jail to await sentencing. But before this could take place, Biebler spent time interrogating both of them for their possible roles in the Earlene Barksdale murder. Even though Brown was reportedly offered immunity to implicate Floyd in the murder and testify against him, Brown refused to do so and continually denied that he had any involvement. However, Floyd eventually told a much different story. Floyd claimed that at around 12:30 p.m. on July the 7th, he and Brown both drove to the Just Kids shop and were accompanied by a third man whom Floyd only knew by his nickname, Poochie. When they arrived, Floyd said that Brown and Poochie went into the shop to perform a robbery while he waited in the car. After about 15 minutes passed, the two men had still not returned, so Floyd decided to go into the shop to check on them. As he went inside, Floyd said he heard a gunshot and he could see the foot of a partially hidden body lying on the floor in the back office. Brown and Poochie soon emerged from the office, and after the three men fled the scene, Floyd said that Brown eventually confessed to having raped and murdered Earlene Barksdale. Well, even though the mysterious Poochie was never identified or located, investigators believed that Floyd's story was strong enough evidence to implicate Brown, so on November the 1st, Brown was charged with first-degree murder, rape, and robbery. For his trial, Brown would be represented by a young, inexperienced defense attorney named J. Michael Shea, who had only recently graduated from law school. Brown had originally been assigned a public defender who was forced to drop out due to a conflict, so Shea agreed to take on his case. However, while Shea initially assumed that Brown had only been charged for his role in the Holiday Inn robbery and was planning to enter a guilty plea, he was taken by complete surprise when he learned that his client had also been charged with murder. Brown's trial would begin in June of 1974 and was prosecuted by Assistant Hillsborough State Attorney Robert Bonanno. Since there was no physical evidence linking Brown to the murder, the state's case against him would rely almost entirely on the testimony of Ronald Floyd. Additional testimony was provided by Raymond Vinson, who was not present when the murder took place, but claimed that he was with Brown and Floyd when they heard a radio broadcast about the crime the following day. When Earlene's murder was mentioned, Floyd reportedly stated, quote, "People will do anything these days," to which Brown replied, quote, "Yes, she never should have done what she did." When questioned on the witness stand, Floyd denied that he had received any plea agreement or special treatment in exchange for testifying against Brown, and Robert Bonanno would repeat this statement during the prosecution's closing statement to the jury. In response, the defense provided alibi testimony from Brown's girlfriend and her foster mother, who both claimed that Brown was with them at their home watching a movie on television during the time period the murder took place. Brown even took the stand to testify in his own defense and continued to deny any involvement in the crime, and he was able to provide accurate details about the movie they watched that day and the TV station where it aired. One of the most controversial issues with the trial was whether or not Raymond Vinson's gun, which Brown had used during the Holiday Inn robbery and provided to the police, was the actual murder weapon. The gun had been turned over to the FBI for ballistics testing, and their report indicated that the bullet removed from Earlene's head belonged to a .38 caliber Smith & Wesson special revolver. The gun Brown provided to police was just a standard .38 caliber Smith & Wesson revolver, so the .38 special bullet would not have even been able to fit inside that gun's chamber. The agent who prepared the ballistics report was on the pretrial list of witnesses, and when he took the stand to testify, J. Michael Shea was planning a dramatic demonstration in which he would ask the agent to put a .38 special bullet into the so-called murder weapon and show the jury that it did not fit. But this strategy backfired when Bonanno elected not to call the agent to the stand, and instead released him to leave on vacation for a fishing trip he had planned in the Gulf Stream. Since Shea had made the mistake of not subpoenaing the agent himself, he requested a continuance from Hillsborough Circuit Judge Robert Rollins in order to track the agent down. Judge Rollins denied this request, stating, quote, "Mr. Shea, I assure you we are going to finish this case tomorrow," end quote. Well, after the prosecution and the defense both made their closing arguments to the jury, Shea was taken off guard when Bonanno decided to make this statement during a final rebuttal argument. Quote, "They say it's a .38 caliber pistol, .38 caliber bullet. We have a .38 caliber pistol," end quote. This gave off the impression that Brown's gun had been positively identified as the murder weapon, and since defense attorneys are not permitted to respond to prosecutors' rebuttal arguments, Shea was unable to dispute Bonanno's statement in open court. The trial lasted a total of 4 days, and on June the 28th, after deliberating for only 1 hour and 55 minutes, the all-white jury consisting of 9 men and 3 women found Brown guilty on the charges of first-degree murder, rape, and robbery. Since Shea believed the state's case against his client was incredibly weak and was certain Brown would be acquitted, he did not even bother to prepare for the capital sentencing phase. Well, after the sentencing hearing took place, the jury only had to deliberate for 15 minutes before they decided that Brown should receive 2 consecutive life sentences for the robbery and rape convictions and be sentenced to death for murdering Earlene Barksdale. Judge Rollins concurred with the jury's recommendation and ruled that Brown would be sent to death row at Florida State Prison in order to be executed via the electric chair. Following the conclusion of the trial, Brown wound up receiving an additional 20-year sentence for the Holiday Inn robbery, while Ronald Floyd received probation for the same crime. It would later turn out that the robbery's case file contained a confidential pre-sentencing report with this passage, quote, "Detective Biebler has requested the sentencing of Ronald Floyd and Joseph Green Brown be postponed until the Barksdale murder case is developed," end quote. Unfortunately for Shea, he was never provided with this report, and it wasn't long before the state's case against Brown started falling apart. Months after the conclusion of the trial, Ronald Floyd wound up violating the terms of his probation when he was picked up in a bar carrying a gun. He would be charged with carrying a concealed weapon and being a felon in possession of a firearm, and received a 99-year prison sentence. In March of 1975, Shea paid a visit to Floyd in prison, and he proceeded to completely recant his trial testimony. Floyd provided a sworn affidavit stating that neither he nor Brown had any involvement in Earlene Barksdale's murder, and the third individual he had placed at the scene, the mysterious Poochie, did not actually exist. Floyd now admitted that he pretty much decided to falsely implicate Brown in the crime out of revenge because he was angry that Brown had ratted him out on the Holiday Inn robbery. Floyd also claimed that he lied on the witness stand when he denied receiving any plea agreement from the prosecution, as they had already offered him probation on the robbery charge if he agreed to testify against Brown. In order to coach and prepare him for his testimony, Floyd said that Detective Biebler took him to the Just Kid shop in order to familiarize him with the layout of the murder scene. When an evidentiary hearing was held in court to address this issue, Judge Rollins warned Floyd multiple times that he could be charged with perjury for recanting his testimony. This eventually prompted Floyd to change his story again and recant most of the statements he had made in the affidavit. Over the next several years, Brown's defense team would appeal his conviction numerous times, but all of his requests for a new trial were denied. At the request of the NAACP Legal Defense and Education Fund, Brown's case wound up in the hands of volunteer counsel Richard Blumenthal, who eventually became Attorney General of Connecticut, and at the time of this recording, is an incumbent senior United States Senator. Even though Blumenthal had been a prosecutor who ordinarily supported the death penalty, he found Brown's case to be so outrageous that he agreed to represent him pro bono and put up $40,000 of his own money towards the investigation. At one point, Blumenthal tried to get Brown's death sentence overturned on the grounds of ineffective counsel during his original trial, but he was unsuccessful. In September of 1983, after 9 years on death row, Brown had his death warrant signed by Florida Governor Bob Graham, and his execution was scheduled to take place on the morning of October the 18th. His attorneys filed a new appeal in federal court, and Brown was only 15 hours away from being placed in the electric chair when he finally received a last-minute stay from U.S. District Judge William Terrell Hodges, who wanted more time to review the case. It turned out that after serving just under 7 years of his 99-year sentence for violating his probation, Ronald Floyd had been released on parole in July of 1981. He once again decided to recant his original trial testimony, and this time he agreed to provide a videotaped deposition. Floyd maintained that his story implicating Brown in the murder was completely fabricated, and he was offered a favorable plea agreement from the prosecution in order to testify against Brown. Floyd also feared that if he didn't falsely implicate Brown, the authorities likely would have charged him with the crime instead. Even though he had granted Brown a stay of execution, Judge Hodges ultimately decided to turn down his request for a new trial, but the case would be heard again by the U.S. Court of Appeals for the 11th Circuit. On March the 17th, 1986, they decided to overturn Brown's conviction on the grounds that the state had knowingly allowed false testimony to be used against him at his trial, which violated the Due Process Clause of the 14th Amendment. A new trial was ordered, and Brown would be transferred from death row to the Hillsborough County Jail. Brown would remain there for nearly a year while the state decided whether or not to retry him, but since Floyd's recantations no longer made him a credible witness, they decided that there was just not enough evidence to secure a conviction again. So on March the 5th, 1987, the Hillsborough State Attorney's Office announced that they were dropping the charges against Brown, and he was finally released after having served over 13 years behind bars. Unfortunately for Brown, he did not receive any compensation for his conviction, but he made it his new mission to become an outspoken advocate against the death penalty and prosecutorial misconduct. While incarcerated, he had taken on a new name, Shabaka Waklimi, which is Swahili for uncompromising teacher of truth. After moving to Washington, D.C., Brown became involved with a woman named Mamie Caldwell, who worked for the U.S. Labor Department and had 3 children from a previous marriage, and the couple wound up marrying in 1988. Over the course of the next several years, Brown constantly did speaking engagements at schools, churches, and other locations in which he shared his story about his time on death row. In fact, on July the 23rd, 1993, he appeared in front of a U.S. House Judiciary Subcommittee where he spoke about the injustice of the death penalty. The case wound up returning the spotlight again in 2001 when Brown's original defense attorney, J. Michael Shea, released a fictionalized book he had written about the case titled The Penalty. The characters in this story were clearly modeled after real people, and Shea was not too subtle about this since he gave them names like Joseph Brown Green and Elaine Bloomingdale. Shea said that he had to write the book as a work of fiction in order to avoid making public accusations against real people. Indeed, the story contained a character named Fred Bloomingdale who was clearly based on Fred Barksdale, and during an interview with the Tampa Bay Times, Shea stated, quote, "There appear to be a lot of unanswered questions about Mr. Barksdale's involvement," end quote. I mentioned earlier that even though Earlene had taken Fred's last name, he was still legally married to his wife, Susan Barksdale, at the time of Earlene's murder. Fred and Susan were not officially divorced until just 4 days before Brown's trial, where Fred was called upon to testify as a witness. Oddly, Fred stated under oath that he was married to Earlene at the time of her death, even though they had never legally wed. In the years following the trial, Fred would find himself facing legal troubles of his own. In 1977, the Tampa Tribune published an expose about how Fred and his law partner, Abe Regau, had built up a remarkably successful practice defending DUI cases. It seemed like the two attorneys had a very high winning percentage for clients who were arrested on DUI charges, as a large number of them would either have their charges dropped or receive reduced sentences. Curiously, these cases were never listed on the docket for the city's main traffic judge, Bob M. Johnson, and when the Tribune reporters looked at the disposition records in the original case files, they did not find Judge Johnson's signature, but rather the notation, quote, BMJ-JH. Well, JH just happened to be the initials of Julianne Holt, who was Judge Johnson's clerk at the time, and had also worked for Fred Barksdale. When the FBI got wind of this, they became convinced that Fred and his associates had a racket going on, which involved secret payoffs to make DUI charges go away. But even though the FBI gradually built up a racketeering case against them, the Justice Department declined to prosecute. However, in October of 1980, Fred was indicted for income tax evasion after the IRS discovered that he had failed to report around $70,000 in income from his DUI cases. While this was going on, Fred had also contacted a number of his former clients and told them to destroy any records they had of their payments to him before the documents could be seized by IRS agents. Fred wound up receiving a 6-year prison sentence and served 18 months before his release, and he also lost his law license. Fred was still alive by the time the penalty was published, and he continued to deny any involvement in Earlene's murder, expressing his opinion that Joseph Green Brown was still guilty of the crime. Fred wound up passing away in February of 2005 at the age of 83. However, one person who was still seeking justice for Earlene's murder was Matt Evans, her oldest son from her first marriage. In fact, Matt would openly express his belief that since his mother did not have any marks on her body and there was no sign of struggle at the scene, she may not have been raped at all, but willingly took off her clothes and had consensual sex with the person who subsequently shot her. Even though Fred had told police that he did not own a gun, Matt recalled Fred owning at least 2 handguns back in 1973. Following the release of the penalty, Matt met up with J. Michael Shea, who told him that semen samples had been found on Earlene's body, clothing, and a piece of carpet from the shop. Of course, DNA profiling was not an option back in 1973, but there was hope that new testing on the seminal fluids might uncover the identity of Earlene's real killer. While all evidence related to the case was maintained by the Office of the Clerk of Courts, it would turn out that in March of 1988, 1 year after Brown's release, the evidence had been sent to the Hillsborough County Sheriff's Office, where it was subsequently destroyed. This made DNA testing impossible, and even though Matt approached the new Hillsborough State Attorney and inquired about the possibility of taking another look at his mother's murder, he was told they could not reopen the case without physical evidence. As for Joseph Green Brown, there would be a shocking epilogue to his story. By 2012, Joseph was 62 years old, and his wife, Mamie Campbell Brown, was 71, and they were living in Charlotte, North Carolina. On September the 13th of that year, Mamie's family had no luck contacting her or Joseph on their landline or cell phones, so they requested that the local police perform a welfare check at her apartment. When the police arrived, they discovered that a violent struggle had taken place, as Mamie had been stabbed and strangled to death, and her body was now lying on the bathroom floor, covered with a blanket. Since Mamie's car was gone, and Joseph was nowhere to be found, it seemed likely he had committed the crime and fled the scene. Sure enough, the following day, Joseph was tracked down to a hotel in his original hometown of Charleston, South Carolina, and he was arrested and charged with first-degree murder. There were a number of warning signs that the couple's marriage had been coming apart over the past several years. In 2003 and 2005, Mamie had filed separate domestic abuse complaints against Joseph and was granted a temporary restraining order, though she ultimately decided to drop both of her complaints. The couple had also been experiencing serious financial problems as they were forced to relocate from Maryland to Charlotte following the foreclosure of their home in 2008. Joseph had also not paid taxes on the fees he received from his speaking engagements over the years, so Mamie was pretty much financially supporting him, and there were strong indicators that she was finally planning to end their marriage. On September the 12th, 2013, Brown pled guilty to the lesser charge of second-degree murder, and after expressing remorse for what he did to his wife, he received a sentence of 15 to 18 years in prison, and he is currently incarcerated at the Pamlico Correctional Institution in Bayboro, North Carolina. In regards to Earlene Barksdale's murder, there have not been any attempts to reopen the investigation, so there's still no conclusive answers about who actually killed her. So I guess you could say the trail went cold. So to call this story a wild roller coaster ride would be an understatement. Here we have a black man, Joseph Green Brown, being accused of raping and murdering a white woman, Earlene Barksdale, in Florida during the 1970s, and given the circumstances of the time period, it should not be surprising that any suspicions about the victim's white prominent spouse, Fred Barksdale, were largely ignored. Green winds up being convicted on very weak evidence and comes dangerously close to being executed before his conviction is finally overturned, and the general consensus seems to be that a horrible miscarriage of justice took place. As the years go on, Green becomes an advocate for the wrongly convicted and an outspoken opponent of the death penalty, and the narrative seems to shift focus towards Fred Barksdale possibly being the real killer. But after being a free man for 25 years, Brown suddenly wounds up being charged and convicted for the murder of his own wife, Mamie, which is a shocking development which I'm sure no one saw coming. So does that change the complexion of this entire case? I mean, there aren't other documented cases of wrongly convicted individuals who have been exonerated and released from prison, and then gone on to commit other crimes which put them back behind bars. The most infamous example is probably Stephen Avery of Making a Murderer fame, who spent 18 years in prison for a rape he did not commit, but wound up being arrested for the murder of Teresa Halbach only 2 years after his release. But unlike the Stephen Avery case, there are no allegations here of Joseph Green Brown being framed or having evidence planted against him, because it's pretty cut and dried that he did murder his wife, and he agreed to plead guilty to the crime without going on trial. For many years, most people who knew Joseph and Mamie believed that their marriage was a happy one, and Joseph gave off the impression of being a nice guy, as in addition to his advocacy work for the wrongly convicted, he spent time working at a homeless shelter and helping people with addiction issues. However, even though Brown's conviction was overturned, he was technically not exonerated per se, as the state never provided him with any compensation or offered any sort of apology, as they pretty much kept up the narrative that Brown was only released because of a technicality, and they would have convicted him again if they just had enough evidence. Since Brown was still officially recognized as a convicted murderer in the eyes of the law, that made it very difficult for him to find steady employment, which is why he had to rely so heavily on speaking engagements for his income. Throughout the years, Green did have a few scrapes with the law, including the domestic abuse complaints his wife filed against him, but the charges were usually dropped, and he never had to return to jail until he committed murder. Last year, this story was featured on an episode of the Investigation Discovery true crime series American Monster, which means that Joseph Green Brown's legacy is now that of a man who brutally murdered his wife, rather than an advocate who tried to use his own traumatic experience to make the world a better place. Brown will not be eligible for release from prison until at least 2027, at which point he'll be 77 years old, so time will tell if he ever becomes a free man again. But of course, this shocking turn of events has only opened up a disturbing possibility. Could Brown have actually been guilty of the murder of Earlene Barksdale all along? Well, even though Brown is officially listed on many websites as a wrongly convicted exoneree, he technically had his conviction overturned due to prosecutorial misconduct and civil rights violations, not because new evidence conclusively proved that he did not do it. Back when this happened in 1986, DNA profiling was still a relatively new thing, and since all the physical evidence from this case has since been destroyed, Brown never got the opportunity to perform DNA testing and truly exonerate himself. But it goes without saying that the original case against him was incredibly weak, as it relied almost entirely on the testimony of a criminal, Ronald Floyd, who conveniently painted himself as an innocent victim who simply waited in the car while the murder occurred, and he had no idea anyone was going to get hurt. There certainly was not enough evidence to convict Brown beyond a reasonable doubt, which is why it's incredibly disturbing that it took less than 2 hours for the jury to reach their guilty verdict. While I don't automatically want to accuse them of racism just because they were an all-white jury, one of the jurors would later say that the N-word was thrown around a lot during deliberations, so you get the sense that they may have already made up their minds about Brown's guilt before the trial even began. The state also presented a false narrative that the gun Brown turned over to the police was the murder weapon, even though ballistic tests showed this was not the case, and the bullet found in Earlene's head could not even fit in that revolver. That whole situation was a serious act of misconduct which should have gotten the entire case thrown out, and it was clear that prosecutor Robert Bonanno was using every sneaky trick in the book to plant this information in the jury's heads, because he knew that Brown's defense attorney, J. Michael Shea, was way too inexperienced for a murder trial of this magnitude. And of course, Bonanno flat out lied in open court about not having offered Floyd a plea agreement in exchange for his testimony, and he never really suffered any real consequences for his actions, since he eventually wound up becoming a circuit judge. If you look at Bonanno's background, you will see that his career was tainted with controversy and numerous allegations of ethics violations. In fact, in December of 2001, around the same time period this case started garnering attention in the media again, Bonanno was supposed to appear before a Florida House committee for an impeachment hearing, but then he suddenly decided to resign from the bench and is pretty much settled into a quiet retirement. To me, the fact that the authorities went to the trouble of destroying all the evidence after Brown was released from prison is the biggest red flag, because technically, they could have charged him with the crime and taken him to trial again if they felt they could get a conviction, but that obviously would never happen if the evidence was no longer around. Even if Brown was guilty, the destruction of the evidence shows that the state did not have 100% confidence in their case, and were terrified that forensic testing might eventually prove beyond a shadow of a doubt that they sent an innocent man to death row and came within less than 1 day of executing him. Now, even if you put aside the murder of his wife, Joseph Green Brown was obviously not a saint before he was arrested for this crime, as he participated in a robbery and forced a woman to strip while molesting her. At Brown's trial, Roland Floyd testified that he was the one who talked Brown out of raping the woman, but Brown has always told this differently, claiming that when the victim begged him to stop, he reconsidered his actions, stating, quote, "My mother had been hurt once. I never wanted to hurt a lady, no matter who she was," end quote. Regardless of what actually happened, I do have to give Brown credit because he was obviously remorseful to take the initiative to turn himself into the police and confess to everything he did. Even if he had not been convicted of murder and sent to death row, Brown still would have served some years in prison for his involvement in the Holiday Inn robbery. But honestly, if Brown was guilty of the murder of Earlene Barksdale, I have no idea why he would decide to turn himself in for a lesser crime he committed on the exact same day. If he hadn't done that, then Brown may never have popped up on the radar as a potential suspect in this case. I don't understand the logic of expressing remorse for a robbery in which you forced a woman to strip, but not feeling remorseful enough to admit culpability in the rape and murder of another woman. You also have to remember that Floyd's girlfriend and her foster mother both took the stand to testify and provide Floyd with an alibi on the afternoon the crime took place. And since the foster mother was an elderly religious woman in a wheelchair, she did not fit the profile of someone who would perjure herself in order to protect a criminal. It seems to me that once Brown and Floyd were arrested for their roles in the Holiday Inn robbery, Detective William Biebler became so fixated on the similarities between that crime and the Barksdale murder that he became convinced that one or both of those men had to be responsible, and he needed one of them to rat out the other in order to close the case, regardless of whether or not the right person actually got charged. According to Detective Dick Rivette, before charges were filed, there was an incident where he visited the Hillsborough County Jail and overheard Biebler holding an interrogation session where he was screaming obscenities and racial slurs at someone. When Biebler ran into Rivette a short time later, he had Joseph Green Brown with him and yelled, quote, "That effing N-word is the bastard that killed Barksdale's wife," end quote. After Brown took on J. Michael Shea as his defense attorney and shared the story about this interrogation session, Shea warned Biebler to stay away from his client. If Brown had decided to talk first and implicated Floyd in the murder, then Floyd may have wound up being wrongly convicted, and Brown likely would have received a sweet plea deal in which he avoided prison time. But the fact that Brown refused to do so is a strong indicator to me that he had nothing to do with Earlene Barksdale's death. And of course, one of the most ridiculous aspects of this case is Poochie, the non-existent third man who was supposedly involved in the crime and turned out to be a complete fabrication dreamed up by Floyd. I'm sorry, but I just cannot hear that name without thinking of Poochie, the obnoxious cartoon dog who was added as a character onto the Itchy and Scratchy show on The Simpsons. Since Poochie was never found, I can only assume that he said, "I have to go now, my planet needs me," and then Poochie died on the way back to his home planet. But in all seriousness, doesn't it strike anyone as odd that even though Poochie was technically an accessory to murder, the authorities didn't seem to make any attempt to find or even identify him, after Brown was charged with the crime. Yeah, it's pretty obvious they held the mentality that someone had to be held accountable and sent to prison, even if it was an innocent person being convicted on the basis of a false story. So even though Brown did go on to commit another murder 4 decades later, I really don't have any reason to believe he was responsible for killing Earlene Barksdale, and I think he just wound up being a convenient scapegoat. Now, since $100 was missing from the cash register at her shop, it might appear that Earlene was the random victim of a robbery gone wrong, and that someone else entered the establishment and decided to rape and murder her. But the big piece of evidence which goes against that theory is the fact that Earlene was wearing an expensive diamond ring, and whoever killed her elected not to take it when they left the scene. So could the $100 have been taken simply to give off the false impression of a robbery and cover up the real motive for this crime? Well, that's what Detective Rivette originally thought, but he pretty much had the reins taken away from him by Detective Biebler, who soon focused all his energy on Brown and Floyd, and did not even want to consider the possibility that Fred Barksdale might be involved. It seems like Fred dropped off the radar as a potential suspect after he passed a polygraph, but of course, we know how unreliable lie detector tests can be. Since Biebler had a close relationship with Fred, did he genuinely believe that his friend was incapable of murder? Or did Biebler intentionally go the extra mile to protect Fred by pinning the crime on a black man? Well, since Earlene had seminal fluid on different parts of her body, including her mouth and vagina, there has been speculation that she was sexually assaulted by multiple assailants. Of course, there's nothing to say that one person couldn't have left their semen in different locations, but since all the physical evidence has since been destroyed, we no longer have the option of using DNA testing to determine if the seminal fluids belong to more than one person. It's also been reported that no fingerprints were found at the scene, which seems unusual, since you'd expect to at least find Earlene's prints inside her own office, so the perpetrator likely wiped the whole place down before they left. Of course, the alternate theory pushed forward by Earlene's son, Matt Evans, is that there was no rape, and Earlene had consensual sex with the person who killed her. According to Fred, the shop's door was locked when he arrived and found Earlene's body later that night, and while the killer may have locked it themselves when they left the scene, perhaps Earlene locked the door because she didn't want anyone walking into the shop while she was having sex in the back office. Indeed, if this was a random crime committed by a stranger, it's odd that they would go to the trouble of locking the door behind them, but the killer may have elected to do something like that if they did not want Earlene's body to be found until a certain time. But before we explore this idea any further, I have to make mention of a thread about this case, which was made at the Unresolved Mysteries subreddit last year. It contains a comment from a poster under the username NorthFox9881, who claims to be Matt Evans and shares a few interesting tidbits of information which I have not seen mentioned by other sources. As a disclaimer, I have no idea if this poster really is Matt Evans, or if any of the information he shared is accurate, but I'm going to quote their comment word for word. Quote, "Fred did it. He was at St. Pete Beach with my 2 baby half-sisters. He could have easily called any cop in Tampa for a drive-by, but instead, he loaded up all the suitcases and baby gear, drove back to Tampa, dropped my sisters off at the sitter, and then went to the shop. He drove right by the shop on his way to the sitter. The diamond ring was worth $50,000. A dollar bill was found on her. I'm told it's a Greek thing for, don't do this or it will happen to you. His best friend was Greek, and Mom's clothing was folded neatly. What rape victim folds her own clothes?" End quote. Okay, so that's a lot to unpack, and once again, I have no idea if this poster really is Matt, but I do feel we have to address many of those points. Now, as you recall, the relationship between Fred and Earlene was very unusual, as it sounds like she started off as Fred's mistress while he was married to his wife Susan. But even though Fred and Earlene developed a serious relationship and they had 2 daughters together, he never actually divorced Susan and kept splitting time between his 2 separate families. Earlene's 3 children from her previous marriage, of which Matt was the oldest, always maintained they had no idea Fred was still married to Susan until after their mother was killed, and I get the sense that there was no love lost between Fred and Matt. In November of 2001, shortly after the release of J. Michael Shea's book, The Penalty, the alternative newspaper, Creative Loafing, Tampa Bay, published an extensive article about this case, and Fred, who was 80 years old by this point, agreed to be interviewed. And long story short, Fred did not exactly leave a favorable impression. He still believed that Joseph Green Brown was guilty of murdering Earlene, but expressed this opinion in a, shall we say, less than diplomatic fashion, as he used the N-word to describe Brown and flat out stated, quote, "You can put the word down there, underline it as the N-word there. That's what I consider him," end quote. In that same interview, Fred denied Detective Rivette's claims that he admitted there was a window of 3 hours when he could not account for his whereabouts on the day of the murder. Fred also said that he still kept in touch with Earlene's kids, except that, quote-unquote, little asshole Matt, and he went on to complain that on the day of the murder, Matt was too busy partying with high school girls to see if his mother was all right. Well, as you recall, when Earlene did not show up to meet Fred as scheduled at St. Pete Beach, and he failed to reach her on the phone, Fred called Matt and asked him to swing by the Just Kids shop and see if Earlene was there. Matt declined to do so, but if you followed enough true crime, I'm sure you know that it's not uncommon for people who have committed murder to sometimes arrange for other people to find their victim's body in order to help fabricate an alibi for themselves. But even though Fred traveled to St. Pete Beach with his 2 daughters, he flat out admitted to police that there was a window of around 3 hours that day in which no one could account for his whereabouts. For all we know, this could have been the time period when Earlene was killed, as the crime was estimated to have happened sometime during the early afternoon, and Fred did not discover her body until shortly before 10 p.m. That Reddit comment from NorthFox9881, the poster claiming to be Matt, does raise a valid point. Even though Fred could not convince Matt to visit the shop to check on Earlene, he had a close enough relationship with the Tampa Police Department that he easily could have asked one of their officers to swing by the shop if he was that concerned. But instead, he took it upon himself to make the 30-mile drive from St. Pete Beach back to Tampa and drop his 2 daughters off with a babysitter, even though he apparently could have saved himself some time and stopped at the Just Kids shop first, since it was already on the route there. You could interpret that as Fred not wanting his kids around because he already knew he would find Earlene's body in there. But before we start accusing Fred of this crime, we have to explore what the potential motive might have been. I really don't know too many details about his marriage to Susan, but given that his relationship with Earlene had been going on for 12 years at this point, and he had 2 children with her, I have to assume that Susan already knew about it. So I'm not sure Fred would have needed to murder Earlene to cover the whole thing up. But I find the timing interesting that Fred finally divorced Susan only 4 days before Brown's trial, and he testified that he was legally married to Earlene at the time of her murder. Since that wasn't true, Fred technically committed perjury, so it's almost like he was going out of his way to try and paint a positive picture of his relationship with Earlene. Years later, when J. Michael Shea was trying to uncover new evidence to overturn Brown's conviction, he got in contact with Jerry Fox, who had been the co-owner of the Just Kids shop with Earlene and was a good friend of hers. Even though Fred had told the police there were no issues with his relationship with Earlene, Fox claimed this wasn't true and that a short time prior to her death, Earlene had confided in her that the relationship with Fred was strained. Furthermore, Fox said that Fred conducted affairs with a number of different women besides Earlene and Susan. During this time period, Fox was also carrying on an affair of her own with Fred's married law partner, Abe Regau, a former Tampa police officer who was still good friends with a number of cops on the force, including Detective Biebler. In fact, it was the 2 attorneys who had established their mistresses as co-owners of the shop, though they technically still owned the property where the shop was located. Now, during his aforementioned Reddit comment, Matt Evans stated that a dollar bill was found on Earlene's body, which may have been a Greek message for, "Don't do this or it will happen to you." He said that Fred's best friend was Greek, and I have to wonder if he was referring to Abe Regau, though Regau is traditionally a Spanish surname. I previously mentioned that Fred and Regau ran a very successful law practice defending DUI cases and were likely in a racket with a local traffic court judge involving secret payoffs to make their clients' charges go away. This led to Fred going to prison for tax evasion, but it's worth noting that he already had some legal troubles before Earlene's murder even took place. 2 years earlier, Fred pled no contest to the charge of failing to file a prior income tax return and received a 1-year federal prison sentence, but the judge decided to suspend his sentence and impose 3 years of court-supervised probation instead. So the alternate theory which has been pushed forward is that Fred may have murdered Earlene because she knew about illegal activities he was involved in and could have potentially implicated him if their relationship went sour. Now, the other interesting claim from Matt Evans' Reddit post is that when Earlene's body was found, her clothing was neatly folded, which does seem pretty odd if she was the victim of a sexual assault. I have not seen this piece of information corroborated by any official source, but if it is true, that does lend credence to Matt's theory that Earlene took off her own clothes to have consensual sex with someone. And who would she be more likely to have sex with inside her store during business hours than her own spouse? Fred could have made the calculated choice to have sex with Earlene before he murdered her, because this might give off the outward appearance that she was raped by an outside party. Of course, this would be an extraordinarily stupid thing to do today, since DNA testing would be able to identify the source of the semen found at the scene, but back in 1973, no one would have been thinking about that. While I don't have any further details about this, J. Michael Shea once stated in a Tampa Bay Times interview that Earlene was seeing someone else at the time of her murder, so even if the consensual sex theory was correct, that doesn't necessarily mean the killer was Fred. But here's an additional piece of information which might implicate him, though you'll have to take it with a grain of salt, since it was shared secondhand and has never been corroborated. Fred initially told police that he did not even own a gun at the time Earlene was killed, but Matt claims this was not true, as he saw Fred in possession of at least 2 different handguns that particular year. Well, according to J. Michael Shea, a federal agent once told him that in 1980, when Fred was indicted for tax evasion, he was pulled over by federal agents and they found a .38 caliber Smith & Wesson special revolver in his possession. Of course, the bullet in Earlene's head came from a .38 special, and the agents were able to track Fred's gun and determined that he originally purchased it at a Tampa hardware store in 1971, 2 years before the murder. But unfortunately, no one really knows what happened to this .38 special, only that federal agents supposedly disposed of it years after it was seized from Fred. If Earlene's murder was still an open, unsolved case at the time this gun was found, it might have taken the investigation in an entirely new direction, but in 1980, Brown had already been convicted of the crime and was on death row waiting to be executed. There was no reason to believe this .38 special might have been the murder weapon, so no ballistics tests were performed, and another opportunity to potentially link Fred to this crime went down the drain. Over the past few years, DNA profiling and genetic genealogy have made it possible to close a number of cold cases and positively identify a suspect as the killer, even if they were already dead by that point. But since all the physical evidence in this case has been destroyed, that's just not an option, so even if Fred did this, I don't know how they could prove it now. In fact, barring a confession, I'm not sure how anyone could conclusively be linked to this crime, which is why the authorities have declined to reopen the investigation. While Fred Barksdale and many of the investigators and prosecutors who originally worked on this case are now dead, I've always feared that the subsequent conviction of Joseph Green Brown might have complicated the narrative. If Mamie Campbell Brown's murder had taken place a few decades earlier, I'm sure the authorities would have been shouting from the rooftops that this proved Brown was guilty all along and he never should have been let back out onto the streets. One would even argue that if Brown's execution had gone through as planned back in 1983, he never would have met Mamie in the first place, and she might still be alive today. Well, I'm certainly not going to defend Brown's actions, because he is exactly where he belongs for killing his wife, but if he was not responsible for murdering Earlene Barksdale, then he should not have been charged, convicted, and sentenced to death for it. Period. That's just how the justice system works, and unfortunately, it got tainted in a huge way by this case, which is why I still believe that the real killer managed to get away with it. Like I said earlier, without physical evidence, it will be very difficult to truly solve this case, but if by chance you happen to have any information about the murder of Earlene Barksdale, please do contact the appropriate authorities. But if you just have your own thoughts about what happened, feel free to leave me a comment or send me an email to robin.warder@icloud.com. That's robin.warder@icloud.com. Another reminder that The Trail Went Cold is on Patreon, so please visit patreon.com/thetrailwentcold to learn how you can support our podcast and become eligible for some pretty neat rewards. This past month, I released a bonus episode about an infamous case from Unsolved Mysteries, the disappearance of Ann Sigmund, who became a wanted fugitive for the murder of her estranged husband, Charlie Sigmund, and she has not been seen in 35 years. In addition, I've dropped an exclusive bonus episode from my spin-off podcast, The Path Went Chilly, in which myself and my two co-hosts, Jules and Ashley, cover yet another case from Unsolved Mysteries, the 1987 murder of Don Smith. And for our patrons in Tier 3, I've recorded another new audio commentary track, which can be played over a classic episode of Unsolved Mysteries. I'd also like to give a shout out to our most recent listeners who have signed up with us on Patreon this week, and they are Macy S., Tuesday, and Julie I. Thank you all so much for your support. I'm also pleased to announce that later this summer, The Trail Went Cold is going to be appearing at the True Crime Podcast Festival, which is taking place at the Weston Park Central Hotel in Dallas, Texas, from August the 27th to the 28th. Myself and many other prominent true crime podcasts will be in attendance, and there will be a bunch of panel sessions, discussions, and live episodes, so in order to purchase tickets, please visit the website truecrimepodcastfestival.com. That's truecrimepodcastfestival.com. I just wanted to give another shout out to my supporters at the Unsolved Mysteries message board at the Sitcoms Online forum and the Unresolved Mysteries subreddit, which, like I said, has a really interesting thread about this case. I need to provide a big thanks to Miguel Foote, who edits and assembles this podcast together for me, and Vince Nitro, who composes the eerie music you hear on every episode. If you haven't already, you can like us on Facebook, follow us on Twitter, or leave us a rating or review on Apple Podcasts, Stitcher, Google Podcasts, or Spotify. So have yourselves a good week and join us next Wednesday for another brand new episode of The Trail Went Cold.